Good afternoon. Happy Tuesday. I did not expect to be making this video today. I was eating my lunch. And I read on Discord that the state's motion for an extension of time to file their opposition in Earl's appeal was denied. And the case is now at issue. So let's start with a little background. As I understand it, your mileage may vary. A long, long time ago in a galaxy far, far away, I believe in the 80s. Was it the 80s or the 90s? A long time ago. Earl, well, had to have been in the 90s. A long time ago, Earl was arrested for and convicted of raping one woman. Now, the state screwed the pooch. There were other women. They led with their strongest case, the state's theory of prosecution. Texas is just ridiculous for their criminal justice system, apparently. But their thought process was, we have a really good, strong case with this one woman. We will get him convicted with this one woman, and then we will offer the testimony of all these other women who aren't as credible, but hopefully with their testimony, we'll get a better sentence. Instead of charging multiple counts of sexual assault, they charged a single count, and then they wanted to have all the other women come in to make allegations at the end, right? So Earl was found guilty, but his lawyer was not a complete waste of time and space, and his lawyer had filed a motion in limine to exclude any other acts of alleged sexual assault that were not proven in front of the court. And the court granted that motion in limine, which it should. And the state, the DA for the state should have the back of his hand slapped and probably his face slapped and any other slapped things that would be necessary to prevent him from ever trying that stupid tactic again. Because, I mean, you don't have to be an attorney to realize that that's a bad tactic. Then he had a felon with a firearm. He had a grand theft auto. The felon with the firearm one, that came about because he was working security at a bar, and another gentleman decided that he wanted to have sexual intercourse with a female at the bar, and that female declined to do so, and the male, over her insistence, decided to proceed with the coitus. Oddly, Earl stepped in. One would not expect a convicted sexual assaulter to stop another person from committing sexual assault, but he did. And he did so with a firearm, and now he is a felon in possession of a firearm. He didn't do a lot of time. He had a 10-year sentence, I think, for the initial sexual assault. Maybe some time in here and there for the others. Not a lot going on. In the 90s, he was living in I want to say it's a mobile home. It was in a mobile home park, if I'm not mistaken. He was living there with 3 daughters, 1 son, and his then current wife. And the 3 daughters shared one room. I think the son slept on a couch or something. And anyway, the daughter alleges that during this time, Earl did some things that were not so bueno, like drilling holes in the bathroom wall so that he could view them taking the daughters showering. And then at the end, as I think he made some allegation that he wanted to take his daughter. If his daughter was going to date a young man who was older than her, then Earl wanted to take her virginity. That's the allegation, right? Breast touching, I think, was involved. Anyway, none of it good. None of it good. I'm not trying to minimize it. These are the facts as I understand them. That was investigated at the time and got shelved. Don't know why it got shelved. Didn't go anywhere. Fast forward to 2017, 2018, Earl decides it's a good idea to get a lot of publicity by auditing a Shell station, a Shell refinery, that's also owned by a Mexican state oil company, because they were paying off-duty police officers to provide security in their police uniforms, driving police vehicles, etc. And he went down there. The Batosai went down there. Several other people went down there. But unlike the Batosai, Earl decided that he was going to make a bigger stink about it. And he started talking about things like how easy it would be to have a terrorist activity take place at that location. You know, one simple bomb placed one particular place and the whole refinery goes up. And then in a spectacularly creepy moment, he started talking about how he knows where the manager of the Shell refinery, he knows where that guy's kids go to school and when they get off of school and the route they go home and all these other things. And you're just like, why would you say that? Like, bro, like, it doesn't have... You don't have to use small words and spell it out entirely for something to be a threat. It was a threat. It was a implied threat, but it was a definite threat. If someone started talking about my kids like that, oh, you best believe I would take it as a threat. And trust me, I have plenty of, if Earl shows up at my doorstep, I consider him to be a threat, and I will take all actions to neutralize that threat. Entirely. He will no longer be a threat. So I just want to be very clear about my feelings about Earl. I am not an Earl fan. I'm not an Earl supporter. So he's making these threats to the manager of the Shell station. Not surprisingly, the manager of the Shell station and other people probably brought this to the attention of the local police department, saying this dude is cuckoo for Cocoa Puffs. He's making threats. He's publishing them on YouTube. Maybe you should look into him. And so they do. And while they're looking into him, they find, wouldn't you know it, this report from back in the 90s that got shelved. Why did it get shelved? That's a great question. What's going on in Texas, man? Their DAs F up. Their police departments F up. What's going on? So, they don't pursue the threats, but they decide to go after this. They find the daughter. They get her to make statements. They go and they interview all the other family members. And the DA decides that they have enough to put them away on this. Now, are they doing this because they actually think they've got a case? Are they doing this because they think this is better than what they got him on for Shell? If they had a good case on Shell, why didn't they ever run with the case on Shell? Maybe they didn't have a good case on that. They decided to go with this case. Is it because they had a good case on this, or because they really wanted to punish him for the Shell stuff? I don't know. You don't know? Anything would be guessing. So, they decide to bring it. They arrest him. And Earl, being dumb, I mean, you already know he was dumb because of his past criminal record. Smart people generally don't accrue criminal records. Generally speaking, the rule is that smart people don't accrue criminal records. Are there exceptions to the rule? Absolutely. But the rule is smart people don't get criminal records. If you're smart, you probably don't need to commit crime. And if you're smart, you're probably smart enough not to get caught for committing a crime. So, as a rule, smart people don't have criminal records. And I know that people are going to be so stupid that they're going to put down in my comments examples of smart people who have criminal records. And I'm going to be like, congratulations. You found the exceptions that I was talking about, you fucking cretins. Ugh. You guys don't realize how much it taxes me to have to deal with you, I swear to God. So, Earl decides to talk about it, and he says all sorts of things about how the district attorney, what was the district? Anyway, he thinks the district attorney's out to get him. But he's talking about it. He's going over and over again about these charges. And by the way, Earl has a scorned lover. Him and Teresa, I'm going to say, in all probability, were lovers. They went together on a trip, just the two of them, to Washington, D.C. There's multiple pictures of them. Earl says they were lovers. I have no reason to doubt it. She acts like a scorned lover, but she hates him. She hates him with a seething, burning passion that I can't imagine why, unless they were scorned, or unless she's a scorned, bitter lover. Earl does have a record of sleeping with unattractive auditors and people on the fringe of being on auditors. My guess is that he slept with her, because that's the only explanation I have for her actions, for her vehemence against him. I mean, one time traveling to Washington, D.C., and the next minute, F that guy and just doing whatever she can to tear him down. At the trial, she appears. The crayon eater, Dougie Fresh, the crayon bandit, a complete imbecile who also who has no life, absolutely no life. And so he tries to insert himself into criminal proceedings. He inserted himself into the criminal proceeding for some firearms, like having a firearm in a vehicle or something like that OG2 was in. The guy writes in crayons like a 5-year-old. He went to a Open Carry Texas rally to hand out these crayon made flyers about Earl. So Teresa appeared and Dougie appeared. Probably some others appeared that hate Earl. And these people can't keep their fucking mouths shut. They shouldn't have been there in the first place, but they couldn't keep their mouths shut. On the allegedly pro-Earl side, you had, who's that idiot? The moron with the missing tooth. Fat, diabetic, likes dildos. Why can't I think of his name? You could diddle dogs, or you could diddle kids, and I don't care as long as you film or photograph the police. That guy, Jack Miller, Texas Sheepdog. That guy showed up on a pro-Earl side, and the Gadfly, something like Good Citizen, something or the other. I don't remember his name, but an annoying little twat showed up on the pro-Earl side. So on the anti-Earl side, you had Teresa and Dougie communicating with jurors and saying things about Earl in the hallway where the jurors could hear it. This whole thing was being held for some reason at the family law court. Something about maybe there was something going on where it had to be held at the family law court. So it wasn't really set up for criminal matters, is my understanding. I could be wrong. So they weren't able to isolate the jurors from these other people. And then you had, and so I believe that Jack entertained some of these interactions with Dougie and or Teresa. And then you had the Gadfly. He followed while recording. He followed the jurors to their cars or towards their car, and tried to insert himself in with them. And I mean, it was just a fucking mess. In addition to that, there were some other points that appear, at least maybe not in the transcript of the trial, which I don't remember. I don't think I've read, but it's brought out in in various pleadings that I have been able to read post-trial that things were made, assertions were made that like Earl was racist and he kicked out his wife because she was having a mixed race child, and that Earl was Mormon, and that he that one of the tenets of Mormonism that Earl believed in was that fathers could marry their daughters or something. There were these various assertions that the prosecution made that were prejudicial, even if they were true, which I'm not saying that they were, but even if they were true, they're very prejudicial, and they don't go towards the heart of the issue, towards the elements of the crime. Did Earl sexually assault his daughter? That's the pending question. Whether he's a racist or not is immaterial. Whether he's Mormon or not is immaterial. The tenets of the Mormon faith are immaterial. So there are all these compounding points of what could potentially be error. And so after the trial, Earl gets a new attorney. His prior attorney admits, which is dangerous for an attorney to do. His prior attorney says, I gave ineffective assistance of counsel. I should have objected to this, and this, and I failed to do so. And it wasn't part of my strategy to fail to do so. And, that's potential grounds for malpractice. So attorneys are unlikely to do that. That's potential grounds for sanctions. It's again, his attorney went out on a limb for him. And attorneys we're mercenaries. We are mercenaries. We are not there. I don't think that his attorney has some special love for Earl. So he has a new attorney now. Earl has a new attorney, and this new attorney files a motion for a new trial and lays out all these points. And one of the points is that the court has to look at what a reasonable juror would do. Not what the jurors did in this situation, but what a reasonable juror would do. And I called it out at the time. I said specifically at the time that this is a problem because at the motion hearing, the judge talked about what his jurors did and not what a reasonable juror would do, or if a reasonable juror could be swayed by this, or if it could be tainted by any of these things. And even during the trial, I thought there was something kind of weird because they went home one day on like a 6-5 split, or they had a pretty big split, and the next day, pretty quickly, they put it all together. And it turns out that the judge talked about this stuff being on the internet, and he talked about this is like a real big drama situation, and he said some things which in and of themselves would probably be okay, but when you start adding in all of these little points together, it could be also the straw that broke the camel's back. It might just be a straw, but it might be the straw that broke the camel's back. So in the motion for a new trial, it has to be heard by the judge who heard the trial, and the judge who heard the trial said no. But I listened, or I read, I don't remember if I listened to it. I think I read it. I think I read the transcript. When I read, though, I hear it in my head. So maybe I did both. Doesn't matter. I was not impressed by the state's opposition. The state really didn't address all the things. And I think the state knew that the judge was on their side. And the judge didn't really address the finer points of the law, which is not uncommon. I can't tell you the number of times where I've had a beautiful legal argument where it's not even a question of, it's not even a legal question that's like a could go either way. It's, here are all the authorities. Here's a line of unbroken authorities that says that it goes my way. And the judge would be like, yeah, I know it says that, but you don't have a court reporter here. You can't appeal this. So, you lose. I'm going to do it my way because I can. It's happened to me enough that I'm irritated by it. But any system where there's humans involved, there's always going to be mistakes. And if I was a judge, I would probably make mistakes too. we're all human, right? So anyway, so the judge says no. So they file this appeal. I want to say it's over a year ago now. It's been a long time. I know they came out with judgment in like August of 2023. So it hasn't been a year yet. And then or maybe that was the motion for a hearing, or maybe that was when they filed the appeal. I don't know. It's been a long time. And like I said, the state, Texas, has asked, I think they had 5 requests for continuance. Oh, no, it wasn't the same. I think the Earl's attorney asked for 1. I think the state asked for 4, but they got an extra one because when their brief was due one time, they filed a motion that said, hey, you're supposed to redact the names of victims in appeals, and you didn't. And so Earl's attorney's like, oh, yeah, here you go. Here's a redacted one. And then that started their clock again. So, I mean, they've had a lot of time to respond to this. So their last time, they had till April 8th to file their opposition. On April 9th, instead of filing their opposition, they filed another request to continue. They asked until April 12th. Normally they'd asked for another month. This time they only asked for until April 12th. My firm expectation was they would file their opposition on April 12th, and at some time after April 12th, seeing that the opposition had been filed, the court would be like, yep, fine, okay. We'll grant your motion, and then the motion goes in, and the opposition is retroactively considered to be filed on the 12th. And the court looked. In this case, the court looked to see if the state had actually filed its opposition on the 12th, and the state hadn't. So that means that the state does not get to argue this. That's my understanding anyway. The state doesn't get to argue this. So what the court is going to have to proceed on is the transcript, the clerk's transcript, and the reporter's transcript. They're 2 different things. The clerk's transcript, maybe I'm applying California law, I'm going to assume it's about the same in Texas law. The clerk's transcript is all the filings and exhibits in the case. So the exhibits would be part of the clerk's transcript. Any motions that were filed would be in the clerk's transcript, like the motions in limine, the pretrial motions for this hearing, that hearing, the other hearing. All that would be in the clerk's transcript. The reporter's transcript would be the actual things that were said at all of the hearings, including the trial. There should be a court reporter, stenographer, whatever you want to call that person, at all the criminal hearings, because any one of those things may make grounds for an appeal. So there's probably a Texas requirement. I know there was a court reporter at the trial because they reproduce sections of the transcript in various pleadings post-trial. So the court is going to have all of the arguments that the state made up to and including their opposition to the motion for a new trial. So it's not like the court is going to be bereft of the state's arguments. The court is going to have all of the state's arguments that were made up to that point. They're going to have all the evidence produced at trial. They're going to have the opposition to the motion for a new trial. They're going to have the oral arguments in the motion or in the opposition for the new trial. And then what they're going to do is, most likely, they're not going to have any oral arguments. Most likely, there aren't going to be any oral arguments on the appeal. The Court of Appeals is going to look at the clerk's transcript, at the reporter's transcript, clerk's record, reporter's record, and at the moving papers that Earl's attorney filed in the appeal and make a decision based on that. Now, the motion that Earl's filing is disfavored, meaning that it's very unlikely on it, if it's a 50-50 proposition, Earl loses. It's very unlikely for a motion like this to succeed because he has to show a lot of things. In my first-year family law attorney experience, I think that he showed it. That doesn't make me an Earl supporter. That doesn't mean that I like people who sexually assault their daughters or anybody's daughters. But long before this trial, long before Earl's trial, long before the appeal, back when I was still walking my dogs at 3 in the morning and recording their butts for you guys to watch while I talked, I said that the most important thing, the thing I hope for, is not for Earl to get convicted or Earl to get found not guilty. My hope is that Earl gets a fair trial, because my belief at that time was that Earl was actually guilty. I've always thought Earl was guilty. I don't know what I think now, but I've always thought Earl was guilty up until the motion for a new trial. But my hope was that he would get a fair trial. And the reason why I wanted a fair trial then and now is to put this baby to bed. I know a lot of you are like, ha ha ha, Earl was found guilty. Well, but was it a fair trial? And that's what we're going to find out. We are going to find out from the Court of Appeals whether or not they think Earl got a fair trial. And if they think Earl got a fair trial, great. Right? If they think he did not get a fair trial and they send it back down for a new trial, well, then maybe you should think about it. Maybe you should think about what you thought. Maybe you should reflect a little bit on whether or not you're just coming to a conclusion and sticking by it regardless of the evidence, or if you're allowing the evidence to trickle through and maybe influence your thoughts, your opinions. I can't tell you the number of times I've been wrong. I've been wrong a lot. I could be wrong about this. The Court of Appeals might say, yeah, Earl got a perfectly fair trial. All this is on the up and up. No harm, no foul. Let's move on. Earl might even take it all the way up to the Texas Court of Criminal Appeals. And they might say, Earl, you got a fair trial, buddy. Enjoy being in prison until you're 80-something. And if that's the case, I mean, I'm not going to lose sleep over it. But I'll acknowledge, hey, you know what? I thought that his appeal had a lot of merit. I think based on what I've seen and my understanding of Texas law, and I want to remind you, I'm not a Texas attorney, I think Earl has a good shot. I'm not saying he's going to win. I'm saying he's got a good shot. It's a disfavored motion, but he's ticked a lot of the boxes. I think he's ticked all of the boxes. A court may disagree with me. They've done it before. It won't be the first time, and I won't lose sleep over it. But, if I'm wrong, I'm wrong. And I'll let you know. But this is going to be interesting. It's going to be interesting the way the court comes down. And it's going to be interesting to see if all of the people who were just so sure, if all of them have integrity and can come to me afterwards and say, you know what, John, you were right. Because I'll make a video and say I'm wrong. You know I will. I'll make a video and be like, yep, Court of Appeals said, screw you, Earl. You got a fair shake. I'll make that video. But will you come back and say, you know what? I was wrong. Will you have that integrity? We'll see. I'll bet most of you won't. And I won't lose sleep over that either, because I have very low expectations for my audience and the people who make comments in my comment section. Very low expectations. In fact, if one of you makes an intelligent remark, an insightful one that gets me to think and makes me think that maybe I'm wrong, if one of you manages to do that, it's a rare day. Thanks for watching. Have a great day.